Hi, it's me again, Professor John Blakeman from the UW-Stevens Point Political Science Department, and I'm here with my final two lectures in my series on the U.S. Constitution, sponsored by the UW-Stevens Point Alumni Association and their Alumni College Experience. So these last two lectures, lectures 13 and 14, focus on the First Amendment and especially freedom of speech and expression. And so in these two lectures, we will cover some very, very basic cases in our First Amendment tradition. And hopefully you'll come away with a good understanding of how we view our right to free speech and how we've argued over it historically. But let me give you just some very brief historical examples before we get started. So we can go back to 1798. Where we have President Adams as he's taking a break from the oppressive heat of Washington, D.C. He's traveling back home to his house in New York City for a while, and he's passing through Newark, New Jersey, and he's being honored with a 16-gun salute. Evidently, President Adams wasn't all that popular, perhaps, because one bystander was heard to say, "There goes the president, and they are firing at his blank." And then poor Luther Baldwin was overheard to say, "I don't care if they fire through his blank." And poor Luther Baldwin is arrested. He's prosecuted by the U.S. government for seditious speech, and he's fined $150, which I'm thinking in 1798, that's a lot of money. Then we've got several people in New York City, exactly 100 years ago. Socialists, communists, revolutionaries. And they're saying things like, "Young men, do not let the national government draft you. Don't go to war." We're talking about World War I here. Or, "The enemy of the world is capitalism. Awake, you workers of the world. Let's have a revolution." Well, encouraging young men to avoid the draft, evidently that gets you 6 months in the federal prison system. Advocating for a revolution gets you 20 years in the federal prison system. All right, 50 years ago. Whoa, oh my goodness. We have people actually saying things like the draft in public. Well, that gets you 30 days in the California state prison system. Hey, we have always found it convenient to prosecute and punish speech that we find disagreeable or threatening. No question about that. So here's a poll for you to consider. Actually, a couple of public opinion polls. So the First Amendment Center, very important in helping us think through First Amendment issues. The Center conducts an annual poll. They've been doing so since the mid-1990s. This is their most recent one from 2019. And it turns out when we ask American adults to identify the rights that are embedded in the First Amendment, well, freedom of speech is the one right that the most people can identify. But then again, only 64% of us can point out that the First Amendment contains the right to freedom of speech. That's about 2/3 of us. We could do a lot better than that. In the same poll, 29% of us, not quite 1/3, but 29% is pretty significant. The percentage of American adults who believe the freedoms in the First Amendment go too far. I'm not exactly sure what that means. I really don't want to know. That's sort of scary. The Knight Foundation poll, 2018. This is a poll of college students and high school students. And you know, college students and high school students are always much more libertarian, very, very focused on their rights than adults are. You know, historically, that's just the way it is. And that's great. 89% of students, college students, high school students, agree that people should be allowed to express unpopular opinions. But when we start to narrow it down a little bit, only 45% would agree that people have a right to express offensive messages. I don't really know, or it's hard to say what an offensive message actually is. You sort of know it when you see it, right? Then we look at hate speech. And unfortunately, in these two subsequent lectures, I don't really talk that much about hate speech. It's very controversial, but I think to really understand our ongoing arguments over hate speech, you've got to have a good grounding in the traditions and history of the First Amendment in general, which is what I'm trying to do. But with hate speech, 35% of college students, 35%, a third, agree that hate speech is protected by the First Amendment. 46% of high school students agree that hate speech is protected by the First Amendment. I hate to be the bearer of bad news, but hate speech is protected by the First Amendment outright. The Supreme Court has said so. All right, so there's a lot of stuff to consider here. So in the next couple of lectures, we will look at some early free speech cases, one of which concerns encouraging young men to avoid the draft. Another focuses on encouraging people to have a revolution. And then whether you can say that really bad four-letter word in public. So here we go. And the First Amendment, remember, the part of the Bill of Rights, which was added to the Constitution, 1790, 1791. And the First Amendment is incredibly important because it contains some of the most basic liberties that we have. And just taking a look at it, remember that the First Amendment contains our religious liberty clauses. And so it has what we call the Establishment Clause and the Free Exercise Clause. And the Establishment Clause prohibits the government from establishing a religion. The Free Exercise Clause is an individual right that allows us to freely exercise our religious beliefs. Both of those clauses are incredibly fascinating. A lot of Supreme Court case law goes along with those, and that's a different set of lectures altogether. But then we have the Free Speech Clause, and the Free of Press Clause, and the Freedom to Assemble Clause. And along the way, the Supreme Court has interpreted the First Amendment to also include a right to freedom of association, too. The right to join whatever clubs or groups that you want to join. And so one way to think about it is with the First Amendment alone, there are at least 5 explicit rights spelled out for us. We throw in freedom of association and we get to 6. And the rest of the Bill of Rights is often like that. Many other amendments, like the 4th Amendment, the 5th Amendment, the 6th Amendment, contain a lengthy list each of our specific rights and liberties. Now, a lot of people read the First Amendment and focus on the very first part, Congress shall make no law. Yet that is the way it was written. That is what the states approved in 1790, 1791. But at the end of the Civil War, we get the 14th Amendment, which among other things states that no state shall deprive any person of life, liberty, or property without due process of law. And that specific clause in the 4th Amendment, by the 20th century, the Supreme Court was interpreting the 14th Amendment due process clause to mean that the Bill of Rights also applies to the states. It is, it's historically true that from the mid-1790s all the way into the early 20th century, the general understanding of the Bill of Rights was that it applied to the federal government only. It limited federal power only. The states had their own traditions of rights and liberties. All states have something similar to the Federal Bill of Rights. But with the 14th Amendment in the late 1860s, the calculation changes dramatically. And again, by the time we get to the early 20th century, the Supreme Court is starting to interpret the Bill of Rights as also applicable to the states. through the 14th Amendment. And that's what we call incorporation. The Supreme Court, in a long-running series of cases, incorporates or applies the Bill of Rights to the states, and that includes the First Amendment. Now, a few things to remember as well. First off, our rights enumerated in the Bill of Rights are not absolute. You know, that they can be limited by the government under certain circumstances. And so we rely on the Supreme Court and Supreme Court cases, disputes, to sort of figure out, to tell us as citizens when the government can limit our constitutional rights and when certain types of conduct are not protected by the Bill of Rights. And to fully understand our tradition of rights and liberties in the Bill of Rights, you do in part have to really focus on Supreme Court cases. You should certainly look at presidential proclamations and executive orders. You should look at congressional debates and statutes passed by Congress and signed by the president, and even what happens within state policymaking too. But nonetheless, historically, we tend to rely on the Supreme Court to determine when our rights are protected from the government and when they aren't. And you know, not to put a negative gloss on that at all, historically, the Supreme Court has been more libertarian, that is, more protective of our civil liberties than not. And it turns out to play a vital role in that respect. Now, with freedom of speech and freedom of expression, historically, the Supreme Court has interpreted the First Amendment broadly. It broadly construes our right to freedom of expression, which means the Supreme Court historically is going to be more protective of our right to free speech, our right to express ourselves, more protective of that right than not. The way the Supreme Court goes about interpreting the First Amendment and protecting our right to freedom of expression is through what we call a categories and tests approach. And so one approach from the Supreme Court is it has historically defined categories or types of speech and expression that are not protected by the First Amendment. And the thinking here is these are categories or groups of expression that fall outside of the First Amendment right to free speech and can therefore be regulated by the government if the government chooses to do so. And so, for example, some of those categories, one is obscenity. And obscenity, according to the Supreme Court, has a very specific constitutional definition. Not all pornography is obscene, for example. Pornography is generally protected by the First Amendment. Obscenity is not. There is a distinction, and I'm not going to get into that distinction. That, again, is a completely different area of case law altogether. But within obscenity, the Supreme Court has said that for public safety, public morality grounds to protect the interests of children, child pornography as a subset of expression can be absolutely banned outright. So that's a category of speech that falls outside of the First Amendment. Fighting words, I'll talk about them in a little more detail in a minute. Fighting words are a category of speech that are not protected by the First Amendment. Seditious words or treasonous words maybe are not protected by the First Amendment. I say maybe because I'll illustrate in a few minutes that we banned seditious speech over 200 years ago. But in the intervening centuries, we haven't necessarily sought to do so. True threats is a relatively new category created by the Supreme Court. Those types of words are not protected by the First Amendment either. And a true threat is where someone uses expression against another person, and the hearer, the other person, has a reasonable fear that they will be harmed. Now, again, that's a different area of case law altogether. Defamation, libel and slander, perjury, blackmail, those types of expressions are not protected by the First Amendment. And in general, threats to national security. This is different from treason or sedition. Threats to national security, like leaking government secrets, for example, that's not protected by the First Amendment either. Now, it's important to keep in mind that categories of speech that aren't protected, not protected, are narrowly defined so that the government regulates as little speech as possible within that category. And that if you look at the grand sweep of our freedom of speech and freedom of expression, it's much, much larger than the categories of speech the Supreme Court has defined. So we have a lot more speech and a lot less regulation by the government. Now, along with the categories of speech approach, the Supreme Court also defines what we call constitutional tests. And a constitutional test is simply a formula or a standard that the Supreme Court and lower federal judges and state judges, a standard that judges apply to determine when a government policy is constitutional or not. Constitutional tests are relied upon by local and state policymakers, especially in freedom of expression and freedom of religion cases. They are relied upon by federal policymakers too. So it's not just judges who consume and apply constitutional tests. Policymakers in general are often going to be aware of them because the policies that are made from the local level all the way to the national level may or may not come into conflict with constitutional rights and liberties. So some of the free speech tests that we encounter, two of them I will talk about in a few minutes. The clear and present danger test, which comes from a case Shinc versus United States, and then the bad tendency test, which comes from another case in the same year as Shinc, Abrams versus United States. I'll talk about those. We will read about those in a few minutes. Another interesting test that the Supreme Court created in the early half of the 20th century, the fighting words test, which actually evolves out of the common law. By the case Chaplinsky versus New Hampshire, where the Supreme Court defines the fighting words test for us. And I thought I'd spell the test out for you so you get a sense of the kind of formula that the Supreme Court is putting in place. So fighting words, as the court puts it. Fighting words are words that by their very utterance inflict injury or tend to incite an immediate breach of the peace. That's the formula. The court's rationale is that such words are no essential part of our expression of ideas. Fighting words they don't contribute anything to our discourse with each other. They have slight social value. They are not really valuable as a step to the truth. And so in a sense, the Supreme Court will tell us that fighting words have minimal value in our approach to freedom of expression. They don't contribute much of anything at all. Okay, so that's the reasoning behind it. But the formula itself, first off, fighting words have to be uttered. You can't just think fighting words and be punished for it. You have to actually say them. And then those words have to inflict injury. And historically, the Supreme Court has in mind a physical injury that is caused by your words directed at another person. You know, the idea of psychic harm, mental harm coming from another person's words, it's not unknown in our legal system, but historically the Supreme Court has not really gravitated to support that approach. So the words have to inflict harm, they have to be uttered, they have to inflict some kind of injury, or they tend to incite a breach of peace. There's a probability part to this formula here, right? That the words uttered tend to lead to a breach of the peace. Okay, the Supreme Court is also very clear that the words must be directed at the person of the hearer, which simply means the words have to be directed at a specific person. And there's a lot of case law in lower federal courts and state courts for that matter about whether the words were actually heard by the person they were directed at. So anyway, that gives you a sense of this constitutional test approach, the Supreme Court putting in place a formula, a test, a standard that will allow policymakers and citizens and others to determine when their words are protected by the First Amendment or not. There are a lot of other constitutional tests. Obscenity is a classic one. And in the 1960s and early 1970s, the Supreme Court grappled with a constitutional test for obscenity. You had some justices like Justice White who argued, obscenity, I know it when I see it. That's not very helpful to policymakers when you think about it. You had other justices who had thrown in the towel and said, there's no way we as a court can come up with a workable standard of obscenity. So let's just quit this and let the states figure it out on their own. That's sort of what we ended up with. A fascinating area of constitutional law on its own. Defamation and slander, libel and slander, both part of the old common law of defamation. Time, place, and manner. The government, there are constitutional standards in place for the timing of a government regulation of speech, the place where the government regulates speech, the manner in which you can express yourself. Okay, now, ultimately what we end up with, this categorical approach and the constitutional tests, the Supreme Court has made it quite clear to policymakers that they should attempt, when they have to regulate speech, it has to meet that categorical and test approach, and any policy that regulates speech must regulate as little speech as possible. The government, when it has to regulate speech, must do so minimally in order to achieve its policy goals. Historically, though, government policymakers always find it very convenient to regulate freedom of expression. They just do. Now, a good example of this, early in our history, only a few years after the First Amendment is added to the Constitution, we have the Federalists in Congress under the Abrams administration passing the Alien and Sedition laws of 1798. Now, the Federalists passed the Sedition Act, among other things, to stop anti-federalists from criticizing the Abrams administration. And there were several anti-federalist critics who had published letters to the editor or newspaper op-eds, or even uttered things in public. There were several anti-federalists who were arrested, prosecuted, and imprisoned simply for using words critical of the Federalists or the Abrams administration. They were almost all pardoned by President Jefferson after 1800. The Alien and Sedition Acts expired between 1800 and 1801, except for one little bit concerning sedition. We don't need to worry about that. So the law essentially goes away, and we haven't brought it back into effect. It's interesting, in a lot of freedom of expression cases, every now and then a Supreme Court justice will refer to this history of our early history of attempting to regulate freedom of speech and point out that it didn't work out so well. Now, to put freedom of expression, freedom of speech litigation in a different context for you, by the early 20th century, the Supreme Court is starting to focus on free speech issues. It's not really until the 1930s, but especially the 1940s, where it becomes a very important part of the Supreme Court's docket, as we put it, where there is a continual flow of free speech appeals coming up to the justices. Between 1946, the end of World War II, and 1970, the Supreme Court decided on average about 2 free speech cases per year. From 1970 to the present day, it has decided about 6 free speech cases per year on average. And the Supreme Court decides about 80 cases per year, which isn't many at all. To put that in perspective for you, it gets about 8,000 to 9,000 appeals per year. It has the authority to pick and choose which appeals it wants to focus on. So it narrows that number down to about 80, give or take, in a given Supreme Court term. And out of those 80 cases, a small percentage will be free speech cases. But that's been constant. So since the end of World War II all the way to the present day, the Supreme Court has continually focused on freedom of expression cases. This isn't an area of law that's going to go away anytime soon. And I think the fact that the Supreme Court focuses on it on an annual basis shows that it's an area of constitutional law that is constantly evolving. So, 3 interesting cases that we're going to look at. 2 come in 1919, at the end of World War I, although they both pop up towards the end of World War I, 1917 and 1918. Shinc versus U.S. and Abrams versus U.S. Both of those cases concern people being prosecuted under the Espionage Act for engaging in certain types of expression that threaten, arguably, the federal government. Now, a third case, 1971, Cohen versus California. I chose this case because it's a fun case to talk about. You'll see why in a few minutes. Students really like to talk about it. You'll see why in a few minutes as well, for good or bad. But it illustrates some of the tensions that we face in American politics and society when we strive to protect as much expression as we possibly can. So these 3 cases have some similarities. They all concern, I think, what we might call anti-war speech, speech questioning government policies. They have some differences, too. And we have to keep these things in mind. Shinc and Abrams concern the use of leaflets or pamphlets being distributed by people to spread their political message, their anti-war message. In Cohen versus California, we're talking about a message being displayed slightly differently. They come up in different political eras. In 1919, the Supreme Court is first starting to grapple with what the free speech clause means. In Cohen versus California, 1971, the Supreme Court has dealt with a lot of free speech cases for a good bit of the 20th century. Free speech law is relatively set in one sense, but Cohen comes up at a time of the rise of the counterculture and protests against Vietnam. And so it presents a slightly different dilemma for us. Timing and location of the speech. We'll see this is very important as well, okay? So, we'll get to the Shinc and Abrams cases in just a second, but let me give you some background first. And so Shinc comes up in early 1919. That's when the Supreme Court gives its opinion. That case starts, I think, in 1917 with a prosecution of Mr. Shinc and others for distributing leaflets. And the leaflets, I know you can't really read the leaflet there, but the leaflet it's directed at young men who are being drafted by the U.S. government to go into the Army, and then they're being shipped out to Europe to fight in World War I. Shinc is a member of the Socialist Party of the United States, and he helped write the leaflet. He distributes the leaflet. He distributes the leaflet in New York City, and I'll explain why this is important in just a second. But what the leaflet says is it says to young men, look, you have a constitutional right not to be drafted. Assert your rights. Don't be drafted. Avoid the draft. Now, why timing and context are very important here. Why New York City? Well, that happens to be where Mr. Shinc lives and where the Socialist Party is headquartered. But it's more than that. In 1917, almost all troops being shipped to World War I and the European theater leave New York City. So you have this flow of thousands of young men into New York City after they've been drafted to get on troop ships to leave for Europe. And so New York City is critical here, because if these leaflets get into the young draftees, then arguably the federal government has a crisis on its hands. And the young men who've been drafted and who are lining up literally to board a troop ship, they might read this leaflet and think otherwise. So we will come back to that when we get to the case. Justice Oliver Wendell Holmes writes the Supreme Court's opinion, and he announces what is probably the first test for the free speech clause, the clear and present danger test, which arguably is probably still around. Now we'll look at that clear and present danger test in a second. The next case that comes up, Abrams versus the United States, also New York City, also a similar time frame. We have Mr. Abrams and others who are members of the Socialist Party. They are arrested under the Espionage Act, and they are prosecuted for the crime of threatening to undermine the government. They are, like Mr. Shinc, they are distributing leaflets. But instead of encouraging and advocating young men to not get drafted or to drop out, Abrams and others are encouraging American workers to unite, to rise up, to not join the war effort, which is a capitalist war effort, as they argue. What they're trying to do is essentially foment a revolution, a general strike, where they can get all workers, especially those workers in ammunition factories, armaments factories, to put down their tools and walk off the job. It's different than directly advocating to young men that they avoid the draft. Here, their speech is a little more general, it's maybe a little more unpredictable. Now, what we end up with in the Abrams case, which is decided a few months after Shinc versus US, is a different test for the free speech clause, what's called the bad tendency test. But it's interesting in this case, Oliver Wendell Holmes dissents. He disagrees with the majority's opinion, and he advocates for a third test, what we call the free marketplace of ideas, which is, by the time we get to 1971, the test that we have pretty much ended up with. Now, while Oliver Wendell Holmes is here in front of us, I always like to mention this one story. He was appointed to the Supreme Court in 1902. He served for 1932. He's not the longest serving Supreme Court justice in our nation's history. He's one of them. He is the most prolific Supreme Court writer, however. He wrote more opinions for the court, more dissenting opinions, more concurring opinions, plus the sheer number of books and articles that he wrote. He is one of the nation's greatest legal minds ever produced. No question about that. There's a great story. He served with a Massachusetts regiment during the Civil War. And in 1964, he's based in Fort Stevens, which is just outside of Washington, D.C., across the Potomac in Virginia. Abraham Lincoln, President Lincoln, travels out to Fort Stevens to see what's going on, I guess. And evidently, Lincoln, as the story goes, popped his head up above the parapet, only to be shot at by Confederate sharpshooters. Lincoln is the only sitting president to be directly fired at by an enemy combatant in our nation's history. Someone yelled at him, "Get down, you damn fool." Turns out it was Oliver Wendell Holmes. And as you learn more about Oliver Wendell Holmes, you could see him yelling at a president like that. Now, let me briefly introduce Cohen versus California, okay? And what I'll do next is we will go through the Shinc and Abrams case, and then I'll end this lecture and I'll have another lecture on Cohen versus California. Cohen versus California is 1971. And here we have Mr. Cohen, who I think is 17 at the time. He has a nice leather jacket, evidently, and on the back of it, he has written a phrase, F the draft. Yes, he uses a very bad four-letter word that we are not supposed to use. Now, he walks through the Los Angeles County Courthouse. He's on his way to pay a parking ticket. He's wearing the jacket, and he is arrested in the courthouse and charged with violating California's public indecency statute for engaging in offensive conduct. And the question the Supreme Court has to focus on is really, can the state of California criminalize the use of that offensive word? Now, like I said earlier, this is a fun case to teach. And you can understand why students love to talk about this case, because they think it's a blank check for them to use a very bad word in class. And I tell them, I say, you know what, we can talk about this case without using the word, I think. Anyway, so let's get underway with Shinc versus Abrams. I'm sorry, Shinc versus US, and then Abrams versus US. Then I'll end, and then I'll pick up with another lecture on Cohen versus California. So with the Shinc case, and let me get my highlighter up here. There we go. So with the Shinc case, you know, again, we have Mr. Shinc, who has been prosecuted under the Espionage Act for causing and attempting to cause insubordination in the nation's armed forces. In one respect, this makes sense, right? He is actively encouraging young draftees not to go to Europe and fight, to avoid the draft altogether. They're already drafted in a sense. They're lining up to get on troop ships, and he's actively encouraging them not to go. He's also encouraging young men, if you are drafted, do not report, ignore it, assert your constitutional rights. And so timing and location here are important. Justice Holmes writes the opinion, the court is unanimous on this. It's a very short opinion too. And Holmes writes, in impassioned language, it is intimated that conscription, the draft, is despotism in its worst form, a monstrous wrong against humanity. Do not submit to intimidation, Mr. Shinc writes. Now, Holmes goes on to say, well, of course, the documents, the speech, it would not have been sent unless Mr. Shinc intended his words to have an effect. He intended his words to undermine the draft process of the federal government, the shipment of troops from New York City to the European theater of conflict. He meant for that to happen. He meant to obstruct the draft. Otherwise, he wouldn't have used these words, right? That sort of makes sense. There is an element of intent here. We don't need to focus on that so much. But here's the key. Here's the key part of the Shinc opinion. Holmes writes, we admit that in many places and in ordinary times, Shinc's words would have been constitutional. That in a different context, what Shinc is saying would probably be allowable. But the character of every act depends upon the circumstances in which it is done. The use of words, Holmes is saying, depends upon the circumstances in which they are used. And here we get the famous phrase, you're probably already aware of it, the most stringent protection of free speech would not protect a person in falsely shouting fire in a theater and causing a panic. That's what Holmes means by the context, the circumstances of the words that you use. The First Amendment does not protect you if you shout fire in a theater and cause a panic. Circumstances matter. The question in every case, he says, is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger. So, are the words used in such circumstances and in such a way that they clearly and presently threaten? What do they threaten? Well, in this case, the words clearly and presently threaten an evil that Congress can prevent. What's the evil that Congress can prevent? It's undermining the draft. That is evil. So Congress has the authority to run an orderly draft system. Words that clearly and presently undermine that draft system can be punished. Now, it's not so much the draft and the words used by Mr. Shinc. It's the important point that Holmes is making about the circumstances, the character of every act, the words used. It depends on the circumstances. Now, the test, the clear and present danger test. When words pose a clear and present danger to some interest of the United States, to sort of rephrase it, the government may be able to ban those words. But clear and present, those are important adjectives, right? So the words must clearly pose a threat. The words must presently, that's a question of timing, presently pose a threat. And in Mr. Shinc's case, the words he used to advocate directly that young men avoid the draft, not go to Europe and fight, that's a clear threat. And the present threat, he's in New York City as troops are embarking to go to Europe, embarking onto troop ships. He's encouraging them not to do that right at the very time they're supposed to be doing it. So clarity and timing, proximity and degree, as Holmes puts it. That's how we judge the questions here. Holmes, remember though that Holmes says, well, in another context, in many places and in ordinary times, Mr. Shinc's words would probably be protected. But they're not here because of the circumstances and the context. So let's skip ahead to Abrams. Decided several months later, here we have Mr. Abrams and several others who are prosecuted under the Espionage Act for using disloyal, scurrilous, abusive language about the form of government of the United States. And they intend to bring down the form of government of the United States and bring it into contempt, scorn, disrepute. They intend to incite, provoke, encourage resistance to the United States during a time of war. Now, remember when this case comes up during World War I. It comes up, they're prosecuted right at about the time Russia is exiting and the Russian Revolution is getting ready to take off. But more than that, from the late 1800s all the way through the 1930s and 1940s into the Cold War, the threat of communist revolution, the threat of socialist revolution globally is something that American policymakers grapple with. And so there's an underlying context to the Abrams case, no doubt about that. It's more than just World War I. It is the threat of a revolution that would undermine the U.S. government and the U.S. constitutional system. No question about that. Okay, so the majority in the case. Here the Supreme Court split. And the majority say, the interpretation we have put on these articles circulated in the greatest port in our land, New York City, and from which great numbers of soldiers were leaving, great quantities of war supplies are being shipped out. It's only a fair interpretation of them. That is the meaning which the authors consciously intended to convey. The authors wanted to bring about a revolution. They wanted to undermine the US government, especially during a time of war. No question about that. And so the majority agree that the plain purpose of Abrams's propaganda was to excite at the supreme crisis in war, to bring about disaffection, sedition, riots, revolution. That's what they wanted to do. Now, of course, understand that that never happened. How close were we to sedition, treason, to riots, to revolution in 1917, 1918, and 1919? Probably not very close. But those things didn't happen. And this is where Justice Holmes departs from the majority. But the language, to get back to the majority, the language of these circulars was intended to provoke and encourage resistance. This is where we get the bad tendency test, although the Supreme Court doesn't use that phrase directly. But words that pose a bad tendency, words that might bring about, might provoke a bad result, those words can be banned. Okay, Holmes and Justice Louis Brandeis fundamentally disagree. You know, Holmes is probably angry that the Supreme Court has departed from his clear and present danger test, but he makes a much more theoretical argument here towards the end. First off, he says, it's only present danger or immediate evil or an intent to bring it about that allows Congress to ban certain types of speech. You know, you can't ban speech that might lead to a revolution or a riot at some indefinite point in the future. It's only the present danger that Congress can ban. Congress cannot forbid all effort to change the mind of the country. That sort of makes sense. You know, as Holmes sees this case, and he's no socialist, he's no communist. You know, if anything, he's somewhat of a social Darwinist. He certainly doesn't want to limit political debate. Congress cannot forbid all efforts to change the mind of the country. And in another case, Holmes writes that if the American public votes to send themselves to a socialist revolution, a hell, as he put it, then so be it. But he's not quite there yet. But for Holmes, as he sees it, the First Amendment protects political speech, speech that is meant to change our minds. The only speech Congress can ban is speech and expression that poses a present, clear danger. But here's the meat of his argument. And he starts off this paragraph here. I don't want to go all the way through it, but it's interesting to read. Persecution for the expression of opinions seems to me perfectly logical. He's being ironic, right? But he goes on to say, when men have realized that time has upset many fighting faiths, they may come to believe that the ultimate good desired is better reached by the free trade in ideas, that the best test of truth is the power of the thought to get itself accepted in the competition of the market. That's what we call the marketplace of ideas approach. That the First Amendment, as Justice Holmes sees it, sets up a free marketplace of ideas. And any of us can walk into that marketplace, throw our ideas out for other people to consume. We can consume other ideas that we find in the marketplace. And over time, since it's a free marketplace of ideas, the public decides which ideas it will value and which ideas it will not value. That's, in a sense, how a free marketplace works, right? We, the consumer, in a sense, determine the price of goods and service. Now, it doesn't always work that way. Um, Obviously, markets can be blocked and obstructed. We're not going to get into that. From the grand theory that Holmes espouses, we have a free marketplace of ideas. And all of us, as people living in the United States, as individuals with the right to freely express ourselves, we engage in that marketplace of ideas. We can buy ideas, we can sell ideas. Now, if we espouse ideas that no one's interested in or no one buys, well, then the free marketplace works. Anyway, that's the way he sees it. And it's important because by the time we get to the 1960s and 1970s, this is the approach that the Supreme Court has essentially adopted. That the First Amendment sets up a free marketplace of ideas, and the American public determines the value of those ideas. And Holmes says that is the theory of our Constitution. Now, in other parts of the opinion, he talks about how ideas are sort of thrown out by this little man with no credibility, on and on and on. Well, that's what he's getting at, this free marketplace approach. The competition of the marketplace determines what ideas we value, what ideas we don't value, and that's what the First Amendment sets up for us. So, the Shinc case, the Abrams case are very, very interesting for any number of reasons. First, we see the Supreme Court grappling with a constitutional standard for freedom of speech. We get the clear and present danger test. We get the bad tendency test in Abrams. The Supreme Court gets rid of the bad tendency test in Abrams later in the 20th century, and the justices, conservative justices, moderate justices, liberal justices, they all tend in some way or another to gravitate to Holmes's free marketplace of ideas approach. And so it's the Abrams case is interesting in the sense that we have a dissenting opinion that goes on to establish the foundation for Supreme Court majority opinions in the future. It goes on to set essentially the foundation for the development of First Amendment law. Now, we don't have a free marketplace of ideas in all free speech and expression cases, so don't get me wrong, but it's the grand theoretical approach that most justices have gravitated to in the modern era. Okay, so I'll end the free speech lecture here on Shinc and Abrams, and in the next lecture, we'll pick up with Mr. Cohen and his leather jacket. So definitely stick around for that one.